To institutionalize IPOD will ensure that political parties represented in Parliament have their own organ within the National Consultative Forum where they will discuss their unique issues pertaining to them. Further, the mover argued that there will also be a forum for non-represented political parties and political organizations in which non-represented parties also have their own organ to discuss issues pertaining to them. The mover informed the committee that the current Council of the National Consultative Forum will remain for purposes of enforcing the Code of Conduct and dealing with members with matters arising from the two organs. In supporting the proposals contained in the bill, the Attorney General urged clustering the political parties and organizations in Uganda under the National Consultative Forum based on a representation in Parliament, and those that are not represented in Parliament shall promote the spirit of tolerance, dialogue, and peaceful coexistence. Since the clustered political parties and organizations share similar and unique challenges that can be resolved through dialogue among themselves in their respective organs. The Attorney General further reasoned that this approach shall promote transparency, accountability, and adherence to multi-party political system principles provided for under Article 71 of the Constitution by the respective political parties. I'm coming to a conclusion, honourable members. The committee notes that the proposal to create an organ within the National Consultative Forum is intended to institutionalize the Inter-Party Organization for Dialogue as an organ of the NCF. The Inter-Party Organization for Dialogue Uganda is a legal entity incorporated in 2021 with an aim of pursuing and promoting inclusive democracy and the fundamental principles of democracy, good governance, human rights, public interest, non-discrimination, promoting inter-party dialogue and cooperation as a means for dealing with political differences, as well as managing conflict without resorting to undemocratic means. The committee further notes that IPOD was formed in 2009 as a loose coalition of political parties with representation in Parliament, with support from the Netherlands Institute for Multi-Party Democracy, at the request of the government, maybe to support its nascent democracy. That program is very clear. It notes that the institutionalization of IPOD statutory represents a critical step in the evolution of Uganda's democratic governance and political maturity. At institutional level, IPOD will be moving into a direction that is fundamental to its work. Since its inception, IPOD has provided a unique platform where political parties across ideological and partisan divides can engage in a structured, principled, and enhanced informed dialogue. The committee notes that Uganda's political history is characterized by cycles of conflict, contested transitions, and post-election tensions. IPOD has played a stabilizing role during these periods by facilitating inter-party communication, managing disputes, and encouraging tolerance. The committee notes that formalizing IPOD's status through an act of parliament shall provide a permanent institutional home for political dialogue, reduce the reliance on informal or external mediators, strengthen early warning and conflict prevention mechanisms in the political sector, enhance political party accountability for non-violent and issue-based competition. Recommendations. The committee recommends that IPOD should be institutionalized as proposed in clause 2 and 3. In conclusion, Right Honourable Speaker and Honourable Members, the committee recommends that the bill be passed subject to the proposed amendments attached here too.
Thank you.
Right Honourable Speaker, the report is duly signed by 14 members of the committee. Also attached are the minority reports and minutes of the committee meetings. I beg to move, Right Honourable Speaker.
Thank you. Thank you, Chair. Can we have the minority reports? Where are the minority reports?
The minority reports are signed by the Honourable Jonathan Odu and the Honourable Salirwa Asumani.
Thank you, Jana.
Thank you.
Madam Speaker, this morning I notified the chairman of the committee and submitted my minority reports, 3 copies, and to the office of the clerk and the chairman. They were supposed to return to me one copy, which they have not. But since I suspected the sinister motives, I kept one copy in my coat that I will now proceed to read. You may recall that
please read your report. Can I have a copy?
Right Honorable Speaker, this minority report is presented pursuant to Rule 215 of the Rules of Procedure of this Parliament. It descends from the majority report of the Committee on Legal and Parliamentary Affairs on the Political Parties and Organizations Amendment Bill 2025, by the Honorable Nakut Faith Loru, District Woman Representative of Napak District, and seconded by Honorable Mutembuli Yusuf of Bunyole East and the Honorable Afidra Ronald Olema of Tororo County. Dissent. The bill is unconstitutional. That is the first point of dissent, Madam Speaker and members. The bill is unconstitutional. The minority observed that all political parties and organizations that the Political Parties and Organizations Amendment Bill 2025 contravenes the provision of Article 93 of the Constitution of the Republic of Uganda and Rule 130.
Is a procedure matter?
Thank you, Right Honorable Speaker. Madam Speaker, this is a House of Record. I just had the Honorable Dur mention a honorable member by the names of Afidra Ronald and is locating him in a constituency in Tororo. The Honorable Afidra I know of is from Madio Koro. Wouldn't it be procedure right, Madam Speaker, that this record is put correct for posterity?
But was it also necessary to call a member of parliament? Let's present the minority report.
Speaker, part of the documents that have been submitted includes a memorandum submitted by the movers of the bill. They appeared before the committee, and in the opening paragraph, which I can read to you, signed by Honorable Yusuf Mutembuli in the presence of the Honorable Afidra, paragraph 2 says...
Honorable, what is saying? Correction of the constituency, not Tororo County. There is a Angora, Honorable Angora. You mean they have taken over your constituency?
Right, for the Honorable is not a member representing any constituency in Tororo and Tororo County, to be specific. We have Tororo County North, represented by Honorable Geoffrey Kanya. We have Tororo Municipality, represented by Honorable Apollo Yeri, and I do represent Tororo South. So we don't have them on record. Honorable Pendi represents the Greater Tororo, which is West Budama and Tororo County. Thank you very much.
Thank you, Honorable. It is not from the record. It.
Madam Speaker, I take that correction of the record. All I was trying to do was to show the shabbiness of the movers in writing in their own memorandum to the committee that Afidra comes from Tororo. But now that the record has been corrected, I will proceed to highlight the report. So the first area of dissent, Madam Speaker, as I said, is that the bill is unconstitutional. The minority observe that the Political Parties and Organizations Amendment Bill 2025 contravenes the provisions of Article 93 of the Constitution of the Republic of Uganda and Rule 130, Sub-Rule 1, Sub-Rule B and C of the Rules of Procedure of Parliament of Uganda. Extracts from the Statement of Justification of the clauses of the bill signed and presented to the committee by the Honorable Yusuf Mutembuli, MP Bunyole East, in paragraph 2, page 6, is reproduced as follows. The bill in clause 2 proposes to institutionalize IPOD as an organ of the Consultative Forum. The Consultative Forum is currently created under Section 20 of the Principal Act. The National Consultative Forum shall have two organs. A, the organ, and I underline the word organ for emphasis, the organ for political parties and political organizations with representation in Parliament, which shall be known as the Inter-Party Organizations for Dialogue. And B, the organ, I highlight again, the organ for political parties and political organizations without representation in Parliament, which shall be known as the Forum for Represented Political Parties, Non-Represented Political Parties, and Political Organizations. This will ensure that political parties represented in Parliament have their own organ within the National Consultative Forum, where they will discuss their unique issues pertaining to them. Likewise, there will also be a forum for non-represented political parties and political organizations in which the non-represented parties also have their own organ to discuss issues pertaining to them. The current council of the National Consultative Forum will remain for the purpose of enforcing the code and dealing with matters arising from the two organs. End of quote. The Honorable Yusuf Mutembuli was accompanied to the committee by Mr. Serwambala Kabagabe Lawrence, who signed his written submission as the Executive Director, Inter-Party Organization for Dialogue, IPOD. Please, Right Honorable Speaker and members, pay attention to the following extracts from the written submission of Mr. Serwambala. Today, open quotation, today, I respectfully submit that it is time to give IPOD the dignity, durability, and legitimacy it deserves by making it a legal entity. I have underlined that word. By making it a legal entity under the laws of Uganda. That is found in paragraph 5 on page 1. He continues, I ask you on behalf of IPOD and on behalf of all political parties represented in Parliament to champion the legal institutionalizing, I underline that point, of IPOD. That is found in paragraph 4, page 2. I also wish to add that institutionalizing IPOD is even more justified by paragraph 5, page 2, as a statutory body, and I underline the word statutory body. IPOD would be empowered to, 1, enforce rules of engagement and ethical codes of conduct, institutionalize youth and women participation in political dialogue. 3, mandate the regular review of reforms, including those on electoral laws, political finance, and civic education. He continues, such a statutory recognition would also offer structured pathway of emerging political actors to engage with mainstream governance mechanisms, thereby expanding Uganda's democratic base. That is in paragraph 2 on page 4 of Mr. Serwambala's presentation. As a statutory IPOD would be better positioned to, 1, monitor, and members, please pay attention, monitor, evaluate, and report on implementation of agreed up reforms, interface formally with the Electoral Commission, Parliament, and the Executive to track progress, mobilize technical and financial resources with greater autonomy and transparency. Currently, IPOD's operations are donor-funded and dependent on the voluntary participation of political parties. He continues, institutionalizing IPOD will provide it with the legal identity, define government structure, and budgetary allocations from the National Treasury. I will repeat. Provide it with the legal identity, define governance structure, and budgetary allocation from the National Treasury. 2, provide continuity in leadership, programming, and stakeholder engagement. They continue. A statutory foundation would help IPOD transition from a project-based entity to nationally owned and constitutionally anchored institution. That is found in paragraph 2 on page 5. Let IPOD not just be an initiative, but an institution. This is in the concluding paragraph on page 6. End of quotation. It is clear from the written submissions of the movers of the bill and their one-man ally, Mr. Serwambala, that the bill imposes a charge on the Consolidated Fund. Parliament is stopped from proceeding on any bill or a motion for that bill that imposes a statutory charge on the Consolidated Fund. This is in Article 93 of the Constitution and Rule 130, Sub-Rule 1 and 2 of the Rules of Procedure. This is the finding of the minority. The minority finds that the Political Parties and Organizations Amendment Bill 2025, privately moved by the Honorable Nakut Faith Loru, Honorable Mutembuli Yusuf, and Honorable Afidra Ronald Olema, violates Article 93 of the Constitution of the Republic of Uganda, and therefore it is unconstitutional. The other dissent is overthrow of the legal mandates of the other institutions. The minority observed that the Private Members Bill, the Political Parties and Organizations Amendment Bill 2025, intends to overthrow the legal mandates of various institutions conferred by the Constitution and Acts of Parliament. A patient analysis of by the minority observed that Parliament, this institution, Electoral Commission, National Youth Council, National Women's Council, amongst others, will be relegated to be subordinate to IPOD. The mandate to carry out legal reforms is an exclusive preserve of Parliament provided under Article 79. Nobody can make a law to reform issues of elections except this Parliament. 2, the mandate to enforce rules of engagement and conduct amongst political parties is the preserve of the Electoral Commission by law. The mandate to institutionalize women and youth in political spaces is a preserve of the women and national youth councils. The recent policy of the NRM government, as told to us here in this Parliament by the Minister of Public Service, is that MDAs are being rationalized for efficiency and effectiveness by eliminating duplication and wastefulness. This is my finding. The minority finds that the bill interferes with both the constitutional and statutory mandates of Parliament, Cabinet, Electoral Commission, National Youth Council, National Women's Council, and potentially amends by infection several acts of Parliament which will likely plunge government into conflicts and confusion. It is further found that provisions of the bill appear to contradict the government policy of rationalization, specifically on halting the creations of new bodies, organs, councils, secretariats, etc. The third dissent is on lack of public participation and consultation with political parties. The minority observed that the movers of the Political Parties and Organizations Amendment Bill 2025 did not consult the political parties represented in Parliament and those outside. In fact, the motion seeking leave of Parliament to move a private member's bill was sought and granted to the movers of the bill on the 13th May 2025 around 5 p.m. The order paper listing the bill for the first reading, which was the next day, 14th May 2025, was released on the 14th, just as we are here, on the 13th May 2025, before the bill was even published and gazetted. The bill was published then on the 14th May 2025 and introduced to the House on the same day. The Honorable Chairperson of the Committee of Legal and Parliamentary Affairs scheduled, and indeed the committee held the meetings with the movers on the 15th day of 2025, and today we are here to present the report with only the movers of the bill submitting. It is therefore suspicious that the regulator of the political parties, which is the Electoral Commission, the supervising ministry, Justice and Constitutional Affairs, the political parties represented in Parliament were never consulted by the movers nor the committee. No other stakeholder, including members of Parliament, who had sought, albeit in futility, to move private members' bills on reforms touching political parties and elections, were accorded an opportunity to submit before the committee. The House may recall the vehement submission by the esteemed founding former first son of Uganda, the Honorable Jimmy James Michael Akena Obote, MP Lira City East and party president of the two-time party in government. For those who don't remember, 1962 to 1971 and 1981 to 1985, who is also a member and a former chair of the IPOD. In his submission on record of this House, the Honorable Jimmy James Michael Akena labeled the bill diabolical. The minority found it necessary to recast the dictionary meaning of the word diabolical as below. It means characteristics of a devil, or so evil as to be suggestive of a devil. The second dictionary definition is disgracefully bad and unpleasant. The minority invites the House to pay kind attention and consider the concerns of the party president of UPC, and also recall the concerns of the Honorable Asuman Basalirwa, the party president of JEMA, in as far as implementation of sections 14 of the Political Parties and Organizations Act is concerned. There is no doubt in my mind that the leaders of the political parties in IPOD, who are not members of this House, I have listed them: the Honorable Chagulanyi Robert Sentamo of the official opposition party NUP, the Honorable Amoriat Patrick Oboy of FDC, One Uganda, One People, the Honorable Norbert Mao of DP, Truth and Justice, and Mr. Magara George William of the PPP, if given the opportunity, would equally have opposed this bill, which has been moved without their views. The minority also observes that the regulator of the political parties, which is the Electoral Commission, with powers to sanction political parties and organizations, has powers to sanction political parties and organizations. The sanctions available to the Electoral Commission includes deregistration, which is an equivalent to a death sentence to a political party and organization. The minority is of the considered view that the Electoral Commission has all the tools, should it be necessary, to deal with any political party which is found culpable. The minority did not receive any single evidence of complaint filed by the movers to the Electoral Commission, and further that the Electoral Commission failed to act on such imaginary violations. This is the finding of the minority. The minority finds that the bill is diabolical. You can recall those definitions, and miserably falls short of meeting the provisions of Article 8A of the Constitution in as far as public participation in enactment of legislation is concerned. It is further found that the speed at which the Political Parties and Organizations Amendment Bill 2025 is being rushed is greatly disconnected with the urgency required and expected of Parliament to solve the contemporary challenges facing Ugandans in the areas of decent jobs, improvement in the healthcare services, provision of quality education, delivery of fair and speedy justice, amongst others. I think I missed. Let me rephrase that. It is further found that the speed at which the Political Parties and Organizations Amendment Bill 2025 is being rushed is greatly disconnected with the urgency required and expected of Parliament to solve the contemporary challenges facing Ugandans in the areas of creations of decent jobs, improvement of healthcare services, provision of quality education, delivery of fair and speedy justice, amongst others. The other dissenting point is the unreasonableness and the irrationality of the bill. The main justification of the bill is stated by the movers to be to condition and obtain commitment of political parties and organizations to principles of tolerance, dialogue, and peaceful coexistence. Thank you, Madam Speaker. The main justification of the bill is stated by the movers to be to condition or obtain commitment of political parties and organizations to principles of tolerance, dialogue, and peaceful coexistence. The justification is shallow, unreasonable, irrational. At registration, all political parties carefully choose their own principles embedded in their constitutions which guide them. and these are registered with the Electoral Commission. In the absence of the express provisions in the constitution of political parties, the recourse is to the national objectives and direct principles of state policies and Articles 29 and 69 to 76 of the Constitution of the Republic of Uganda. Finding, the minority finds that the Political Parties and Organizations Amendment Bill 2025 is frivolous, vexatious, unjustified, unreasonable, irrational, and irrationally false shortly acute of the constitutional parameters set out in the national objectives and direct principles of the state policy. Conclusion, the minority having found the following: 1, that the provisions of the bill have the effect of imposing a charge on the Consolidated Fund contrary to Article 93 of the Constitution of the Republic of Uganda. 2, that the bill interferes with both constitutional and statutory mandates of Parliament, Cabinet, Electoral Commission, National Youth Council, National Women Council, and potential amendments by infection, several acts of Parliament. 3, that the bill contradicts the government policy of rationalization on creation of new expenditure centers, such as the 2 organs proposed in this bill. 4, that the bill is diabolical and miserably falls short of meeting the provisions of Article 8A of the Constitution as far as participation in enactment of legislation. 5, the Political Parties and Organizations Amendment Bill is frivolous, vexatious, unjustified, unreasonable, and irrational. Now, therefore, it is recommended to Parliament as follows: that no question be proposed upon the Political Parties and Organizations Bill. 2, motions seeking leave to introduce private members' bills should be subjected to rigorous scrutiny by way of extensive debates on the justification for the peculiar circumstances to warrant the grant of leave. If I may add, government must first fail reasonably to provide a bill to have a justification for private membership. B, the Minister of Finance, Planning and Economic Development be cautioned. The Minister of Finance, Planning and Economic Development be cautioned to execute the mandate of the ministry diligently and avoid late-night escapades of issuance of defective certificates of financial implication. Parliament avoids entangling and entertaining motions and bills arising out of petty quarrels and disagreements between individuals and institutions. Lastly, that the Business Committee of Parliament should convene on more regular basis to conduct business as provided in the rules of procedure. Madam Speaker, before I conclude, when a point of law or a point of procedure is raised in this House, it is my humble prayer that you make a ruling substantially. It cannot, a point of law or a preliminary objection cannot be put to vote. That preserve is entirely for the presiding officer. The ruling must be on the record. You cannot say because the points of law are raised. This is provided in our rules, and I request that where I have raised a point of law touching the Constitution, touching our rules, before you give a formal ruling. It is now hereby reported by this person who signed the minority report. Thank you very much.
Thank you, Honorable Doe. The other minority? In the absence of the minority report, Attorney General, we need a response to the issues that are raised, since the government is the one that gave a certificate.
Thank you, Right Honorable Speaker. Right Honorable Speaker and honorable colleagues, I have had the opportunity to read the certificate that was issued by the Ministry of Finance. The plain reading of the same is saying that while there are expenses expected to be used, the money is already in the budget. So what I understood from that there was no imposition. Government had already provided money. This bill is simply reorganizing. It's just simply reorganizing what already exists. So there's a National Consultative Forum for which money has been provided to run the affairs of the National Consultative Forum, and the bill seeks to reorganize. the National Consultative.
Does it have an effect on the money that we have always allocated?
No, Right Honorable. That's our understanding, that any other charge. Now, on the issue of rationalization, I again, Right Honorable Speaker and Honorable colleagues, the National Consultative Forum consists of all the members of all the political parties registered in Uganda. The IPOD that is sought to be introduced, from my understanding, is only relating to a subset of those. All the political parties which are represented in the House are members of the National Consultative Forum. So they are saying we shall have a meeting of the 43 or whatever number you have, but we shall also have another meeting. So I don't think there is anything to do with rationalization here. So I don't know the other issue about the ruling of, I think, Right Honorable Speaker, we may run into a problem if we take the interpretation given by Honorable Odur. We are always discussing matters of law in the House. The principal purpose for which we are here is legislation. And at all points, we are discussing matters of law. So if the Speaker, every time we speak here on a point of law, must pass a rule, then I think that's a wrong interpretation. I have not seen that provision in the rules. Right Honorable Speaker, lastly, this is a minority report. There's been a majority report, a minority report, so the members should now be allowed to debate those reports and then make a decision on how to proceed. I beg to
And these reports are basically to form a debate on the next step. So we'll now open the debate on yes.
Madam Speaker, Madam Speaker, I want to draw your attention to this, the wording.
Honorable, just a minute, Honorable Attorney General, the certificate where it says there has a financial implication, maybe you could make a clarification on that.
Right Honorable, the certificate says this bill has a financial implication which has been provided for in the budget of this institution. Okay. So it is not an imposition of a charge. It is saying that from my reading of this, whatever money you're going to use to do this is already there. So it's not an imposition. They are not imposing a charge on the council. They're actually just spending what has been provided.
Okay.
Madam Speaker, the records of my submissions are already with you, but I want to remind you on this, that before we go to debate, you resolve this matter. Rules regarding settlement of financial matters. A question shall not be proposed upon a bill, motion, an amendment bill, or amendment to a motion which has not been introduced or moved by a minister. If, in the opinion of the Speaker, the object of the bill, motion, an amendment bill, or amendment to the motion is to make provision for the following: A, the imposition of taxation or alteration of taxation, otherwise by reduction, not applicable to this. B, the imposition of a charge upon consolidated fund or other public fund of Uganda, or the alteration of any such otherwise by reduction. And C, the payment issue, etc. The point I'm making is that your opinion as the Speaker let me finish. Your opinion as the Speaker is first required. If the Speaker rules the presiding officer, because these records may form part of other proceedings, so you cannot, as the Speaker, just wish it away. If, in your opinion, what is your opinion on this point?
This certificate, Honorable, this certificate was given by government. And the certificate that was given by government, I have asked the government to respond to the issue whether it imposes a tax or it has an effect on Article 93. And government says it does not have an effect on Article 93. And if government says it does not have, and that is the legal advisor of government, and says it has no effect, then it doesn't. Is a legal advisor, yes, finance.
Right Honorable Speaker, through my minister, I wish to state that the certificate of financial implications which we issued does not create additional financing requirements by government. We have been providing for a budget for political parties. This exists in the budget which we are running now and the budget which we passed on Thursday. What this law is requiring is conditioning access of this money to certain rules and standards. Otherwise, the money which we have been providing will remain the same. And this is why we said this certificate will not impose new financing requirements. It will be financed within the already provided for budget.
So it has no existing imposition of levy on 93.
Madam and honorable members, you will bear with me. If you listen carefully to the submission of the minister, he does not deny a charge on the consolidated fund. All he's saying is that there will not be an additional. The wording of the constitution and the rules does not include the word additional. It just says a charge.
Honorable Dur, we have been providing for money for political parties in this house. And in provision of that money goes to political parties in the house. And that money goes to political parties. What the law is now saying, we have parties in the house that do not subscribe to IPOD. Now, those parties that are in the house must first subscribe to IPOD for them to be able to get what? To get part of this money. There is no additional money that is being added on political parties. It is exactly the same amount that has been there that is going to be distributed according to the numerical strength in the house. But the law is also saying, if you do not operate by being part of IPOD, then you do not qualify. Meaning that if you don't participate in IPOD, the money that is going to be distributed to the other parties that are in IPOD actually will be within them, and it increases on their money. Yes, Dr. Chris. Let's first have Chris.
Thank you very much, Right Honorable Speaker. I think the Honorable Dur should not mislead the House. What Article 93 refers to is for a private member's bill to introduce additional burden, a charge or a tax, which is not applicable in this case. There is no new charge or tax being introduced by the bill. And therefore, I think Andy, he knows it, but he's just taking Parliament for a ride. So I just invite you to cease fire and let the House debate these reports.
Honorable Akamba, Honorable Ole.
Thank you, Right Honorable. Right Honorable, the Article 93 of the Constitution is very clear, and it does not. The current bill does not in any way offend the article. Because, Right Honorable Speaker, I read the article verbatim. It says, in summary, it prohibits Parliament from proceeding on a bill or an amendment unless it is done on behalf of government which imposes a charge on any public fund. Right Honorable Speaker, the political Parties Act, which is already in existence, created a charge on the public fund, and that's not in doubt. All what the bill is saying is how should this money be spent. It does not in any way suggest, there is no single provision that says or proposes that there will be another charge made on the consolidated fund. So in my opinion, the bill is constitutional and it does not offend that Article 93 in any way.
Thank you. Let Odur wind up and...
Thank you, Madam Speaker. This is my last, and then it can be debated. I'm submitting that without prejudice to the issues debated by the Right Honourable Speaker, I request that as per the rules, you give your ruling so that the House can proceed.
I have given my ruling that it does not have an effect on the Consolidated Fund, Article 93, as already stated by the legal advice of government and stated by the Minister of Finance. Honourable members, physically we have 148 members, and then virtually we have 49 members. That takes us to 197. Yes. Honorable Hati.
Madam Speaker, we want to thank the committee, but also to appreciate the issues raised by the minority report, and we have had clarification that actually this bill has no imposition of extra charges. We have also, from the report of the committee, the majority committee, heard that the bill is not diabolic. It's actually intended to organize the current situation of political parties. And having listened to both sides, Madam Speaker, I wanted to move that this House can move to another stage so that we proceed with the bill. I beg to move.
Seconded. Seconded by Baviko Eda Kansi Lukori. By the whole House, with the exception of Odur. I put a question that the political parties and Organizations Amendment Bill 2025 be read. The second time, those in favor say on the contrary, nay. Let's have it.
The Political Parties and Organizations Amendment Bill 2025, Bills Committee stage. Clause 1.
Procedure.
Chair.
Procedure, Honourable Speaker.
Yes.
As a member of the IPOD Summit, I am finding it extremely strange that I cannot even put input on the goings on of IPOD on record. You see, Madam Speaker, every parliament we have debated a memorandum, and there's a current memorandum which is standing for IPOD. And the chair of IPOD for the last 4 years has been NRM.
And if there's any breach, it is NRM who have failed to call a summit or even a council meeting. So it is important that we deal with this actual issue, because what are we correcting? What is the sickness? What is the disease we're correcting? At the moment, the summit has not sat since NRM has been in the chair for 4 years. Yet it's supposed to be 6 months. The provisions which are being brought now are being brought in bad faith, because in the last parliament, under the chairmanship of Honorable Both of Both, IPOD brought it, and I personally presented them to the same committee. Because the increased funding which came in a supplementary of 2020 had IPOD in it. And how was that money to be shared? At that time, political parties were sharing 10 billion per annum. Under the IPOD arrangement, it was increased to 35. We $5 billion going as the 15%, another $5 billion for covering the other 15%, and then 70%, the 25 billion, was on numerical strength. At that time, the president acknowledged that NRM acted in bad faith by not allowing that amendment to pass. They acted in bad faith. The words of the president, unchristian. And now we are going through a process to undermine everything. There's no dialogue here. If we talk about dialogue as a political party, as a leader of a political party, as the political party which first held the first summit from 2009, the first summit was held in December 2018 under my chairmanship. And the principle which we're debating is what we agreed in that. It's under the democratic permit. As a political party, we have not been consulted. How is it that we're debating this issue? And that is why I say it is diabolical. It is not done in the interest of the political party. I speak for UPC. My brother is not part of this. And I'm thankful that Mao is not here to embarrass himself. This is wrong. And we shall all be judged.
Thank you.
Let us be honest.
As IPOD, the member raised her issue. You still have a gap as members of IPOD to go and ensure that you discuss this issue and maybe ask the president not to accept. Close one.
Close one.
Clause 1.
Madam Chair, the committee proposes an amendment to Clause 1 of the bill in the following terms. Clause 1 of the bill is amended by substituting for the proposed subsection 2 the following.
That the House do resume and the Committee of the Whole House reports thereto.
I put a question that the House resumes and the Committee of the Whole House reports thereto. Those in favor say on the contrary, nay. The ayes have it.
Honorable Speaker, the Committee of the Whole House has considered the bill entitled the Political Parties and Organizations Amendment Bill 2025 and passed it with amendment to clause number 1.
Motion for adoption of the report of the Committee of the Whole.
Honorable Speaker, I move that the House adopts the report of the Committee of the Whole House.
I put a question on the report of the Committee of the Whole House is adopted by this House. Those in favor say on the contrary, nay. The ayes have it.
Bill start reading. The Political Parties and Organizations Amendment Bill 2025.
Honorable Mahmood? Yes.
Thank you, Madam Speaker. Madam Speaker, I would like to raise, I think it's actually the Constitution and our rules of government. I can confirm the number of members present. I request that we put on record the number of people attending online so that we can confirm it is 40 senators mentioned.
Honorable, although I mentioned it, I don't know why you don't know what I'm saying. I did it, I mentioned it, and I still maintain what I mentioned. Honorable Mahmood?
Honorable Speaker and honorable members, I move that the motion that the bill entitled the Political Parties and Organizations Amendment Bill 2025 be read the third time and be passed.
I put a question that the political parties and organizations amendment bill 2025 be read the third time and is passed. Those in favor say on the contrary, nay. The ayes have it.
The bill for advance title the Political Parties and Organizations Amendment Act 2025.
That was settled and the bill passed.
Item 5 on the other table. Bill second reading. The Uganda People's Defense Forces Amendment Bill 2025.
Honorable members, the report of Tuesday and Tuesday 2025, the Minister of Defense and Veteran Affairs tabled the bill, the Uganda People's Defense Forces Bill 2025 for the first reading. The bill was read for the first time on the part of the Joint Committee of Defense and Internal Affairs and the Committee of Legal and Governmental Affairs pursuant to Rule 200, the Rules of Procedure. The Joint Committee is now ready to report, and pursuant to Rule 136(1) of the Rules of Procedure, I will invite the Chair for Defense and Veteran Affairs to move the motion to the Defense and the Minister of Defense and Veteran Affairs to move the motion to the
Right, Honorable Speaker, I beg to move that the bill entitled Uganda Defense Forces Amendment Bill 2025 be read for the second.
Seconded by Honorable Mahmoud, Honorable the Vice President, Honorable Mr. Lupo, the Prime Minister, Honorable Nnamdi, the Honorable the Vice, the Deputy PM, Nyango, Honorable Mifa, Honorable Misasisi, Honorable Mbadi, Honorable Akelo, Honorable the youth, the liberty, great, Honorable Minister Mosi, Honorable Finance, Honorable Kasaidia, Shani, Will you speak to your motion?
Honorable Speaker, colleagues, the record of this House has it that this bill is actually intended to rectify, to remedy the existing defects in the law. The last time this Parliament handled this bill was 2005. And the Armed Defense Forces Act 2005 was enacted in 2005 to provide for the regulation of the Armed Defense Forces in accordance with the Act of Procedural 210 of the Constitution. It's a repeal.
Honorable Mayor is not proposed. So here is what it is. And I want to go back there.
It is a bill that reflects the Armed Forces Pensions Act, Constitution 295, and the Armed Defense Forces Act, Cap 307. Since 2005, the defense sector has undergone significant transformation, arising from both emerging threats and opportunities. Several of them were unforeseen and not adequately addressed by the People's Defense Forces Act, Cap 330. The Act, for instance, did not provide a provision of health care for the officers and management of militants. It did not also provide the management of military veterans, management of pensions and conferring of service medals by the defense forces. It is important, right honorable Speaker and colleagues, to note that since 2005, the administrative structure of the People's Defense Forces has evolved. This in turn has led to the Special Forces Command and the Reserve Forces being elevated from divisions and the land forces to independent services. The amendment before you today has taken this into account. Additionally, following the judgment of the Supreme Court in the Constitutional Bill number 2 of 2021, Attorney General Persons, Honorable Michael Ruka, there is need to align the provision of the Act with the Supreme Court decision. This bill, according to the cases to the orders and recommendations of the Supreme Court. And right honorable Speaker and colleagues, I believe that the legislation embedded in the remedies proposed in the bill, one of them is to align the Act with the new government policies and the command, control, and address the glaring gaps in healthcare by providing proper care for officers and military. 3. To harmonize the management of military veterans. 4. To provide for the decentralization of national authorities from the Ministry of Public Service to the Ministry of Defense and General Affairs. 5. To enhance disability compensation to enable fair payment of compensation to officers and militants of the defense forces for injuries sustained while on duty and address the resulting challenges faced by officers and militants dealing with post-traumatic stress disorder. 6. To restructure and re-establish the court-martial in defense forces in accordance with Article 129(1)(d) of the Constitution and prescribe their jurisdiction to provide for the membership and qualification of presiding officers of the courts-martial and for the independence of the courts-martial. 7. To provide for appeals from the courts-martial. 8. To prescribe exceptional circumstances under which civilians may be tried by the courts-martial. Next is to establish a military courts department which shall be responsible for the administration of justice within the defense forces and provide for its membership. Again, to establish a disciplinary unit within the defense forces which shall be responsible for the discipline of the members of the military courts department. And finally on that is to prescribe the arms and ammunition which are the monopoly of the defense forces and classify the stores of the defense forces. Right Honorable Speaker and Honorable colleagues, this law is not about civilians being before courts-martial. This law is about civilians who voluntarily acquire arms, equipments of violence. This law is also about the civilians who voluntarily masquerade as militants. This law is about those who would commit offense with the military or with the help of any military officer to be tried as proposed. Right Honorable Speaker, I want to dispel the fear that this law is targeting 45 million Ugandans. That's a lie. This law is targeting those people who have preoccupation in their minds to commit offense against Ugandans. This law is to protect Ugandans, the vulnerable Ugandans, against violent people who have firearms or who behave like military personnel. I beg to submit.
Thank you, Honorable Minister. I now invite the Chair to give us his report.
Right Honorable Speaker, I wish to lay on table minutes and record of processing of the bill as was referred to us. I beg to lay. Right Honorable Speaker, and I will summarize. On the 13th May 2025, the bill was referred for the first time reading to the committee, and according to Rule 200, Consolidated.
Yes.
Right Honorable Speaker, the chair of the committee intends to dissuade the House that there is no dissenting report. There is a dissenting report that was submitted to the chair of the committee, and rightfully so, he should have probably made us aware that it is there and almost signed by half of the committee.
The chair will bring that. Just be patient, it will come. The chair, after reading his report, will call for the dissenting what? Views.
Right Honorable Speaker, just a few seconds ago, I have been handed over the minority report. I wish to lay the minority report. And there was no intention whatsoever, but the fact is, if there is a second one,
proceed.
But Honorable Speaker,
Another member stop smuggling minority reports in the House. The reports must be received, we upload them and we handle them.
Thank you.
Nobody will be denied to present a minority report, but just bring them in a formal way.
But Honorable Speaker, I wish to present the report of the Consolidated Committees of Defense and Internal Affairs and Legal and Parliamentary Affairs. This bill addresses the policy principles, and briefly, it streamlines the composition of the defense forces and establishes healthcare service for its members. The bill creates a medical board. It defines service offenses. It defines...
The report is being presented.
Let him finish his report.
Yes.
Hansard, capture all the reports. Capture all the reports. Yes, Honorable Wilson, go ahead.
Thank you, Honorable Speaker.
Are you Wilson? What is it?
Yeah, Honorable Speaker, the procedural point I'm raising, I sit in the Committee of Defense and Internal Affairs. Honorable Speaker, you gave the committee the task to look at the bill and come back. And when we were writing the report on Monday, before we reached half of our report, the chairman told honorable members that they are going to Entebbe to attend the caucus and they will come back. We shall continue with the report. Right, Honorable Speaker, the chairman did not come back. And we did not continue with writing our report. Is it procedural right, Honorable Speaker? I don't know where the report came from. Let the chairman clarify to members, because we did not complete writing our report on that day. Right, Honorable Speaker, we need to be very serious. And it's so bad to keep on smuggling what is not agreeable by honorable members. Where did you get this report from? Yet the committee did not complete. Right, Honorable Speaker, let us put the record right. In fact, we did not complete working on this report. And we did not process it.
Honorable, where did you get your dissenting views for you to write a minority report? Because the minority report is, say it. The minority report is signed by you. Where did you get the dissenting views? Chair, continue.
Thank you, Right Honorable Speaker. Right Honorable Speaker, the bill streamlines composition of defense forces. It establishes the health care service of members. It creates a medical board. It defines service offenses, military courts, and reserve force, while restructuring the courts martial per Article 129, 1D of the Constitution. The proposed qualifications of the chairperson of the courts martial to ensure independence and allow for appeals. This bill specifies circumstances under which civilians may be subject to military law and outlines the offenses tried under courts martial. Additionally, Right Honorable Speaker, this bill establishes a military courts department, a disciplinary unit for enforcing discipline within the military court system. It prescribes defense forces exclusive arms and ammunition. It manages veterans affairs and repeals the Uganda Veterans Assistance Board Act, Cap 221, and related matters. This bill, Right Honourable Speaker and Honourable colleagues, addresses the defects in the existing law. The UPDF Act, the Uganda People's Defence Forces Amendment Bill 2025 amends the UPDF Act Cap 330. This act, enacted in 2005, regulates the Uganda People's Defence Forces as provided under Article 2010 of the Constitution, replacing the Armed Forces Pensions Act Cap 295 and Uganda People's Defences Act Cap 307. Notably, the defense sector has undergone significant transformation since 2005, driven by emerging threats and opportunities, many of which the Act does not adequately address. The Act did not include health care for the officers and militants, management of military veterans, pensions management, or service medals conferred by defense forces. Since 2005, the UPDF administrative structure has changed significantly, with Special Forces Command and Reserve Force elevated independent services. The Uganda People's Defence Forces Amendment Bill 2025 reflects this evolution. Additionally, Right Honourable Speaker, the bill seeks to align the Act with the Supreme Court decision in the Constitutional Appeal number 2 of 2021, which is Attorney General versus Honourable Michael Kabaziguruka. What are the objects of this bill? It seeks to amend the UPDF Act Cap 330 to streamline the composition of the organs and structures of the defense forces. It establishes the health care service for members of the defense forces. It establishes a medical board. It provides for the definition of service offenses, the court-martial, military court, and reserve force. It provides for the restructuring and establishment of the courts-martial in the defense forces in accordance with Article 129(1) of the Constitution and prescribe for their jurisdiction. This bill provides for the membership and qualifications of the chairperson and the courts-martial and the independence of the courts-martial. It provides for appeals from the courts-martial. It provides for the exceptional circumstances under which civilians may be subject to military law and prescribe the offenses for which civilians may be tried by the courts-martial. Honourable Speaker, this bill provides for the establishment of the military courts department within the defense forces. It also further provides for the establishment of a disciplinary unit within the defense forces, which shall be responsible for the discipline of the members of the military courts department. Also prescribe the arms and ammunition which are a monopoly of the defense forces and classified stores of the defense forces. It also provides for the management of the Veterans Affairs. It also repeals the Uganda Veterans Assistance Board, Cap 221, and for related matters. Right Honourable Speaker, for the record, we consulted as is demanded by the processing of the bill. We met and held discussions, constructive ones, with stakeholders like the Ministry of Defense and Veterans Affairs. We also met the Attorney General. We held discussion with Office of the Director of Public Prosecutions. While processing this bill, Right Honourable Speaker and Honourable colleagues, we also entertained private legal, in this case, Counsel Julia Mukama. We also entertained and audience to Kampala veterans of the UPDF, who gave us enriching in Attorney General versus Honorable Michael Kabaziguruka, Constitutional Appeal number 2 of 2021, delivered on 30th January 2025. The committee has reviewed the bill's proposals on military justice and court-martial framework. The findings reveal concerns about compliance with constitutional principles, judicial independence, and administration of military justice. 611, the trial of civilians under military law. Clause 29 and Clause 30 of the bill address individuals under military law and the court-martialing of civilians. Clause 29 revises Section 119 of the Principal Act to clarify who falls under military law. The amended Section 117 stipulates that all defense forces members are governed by military law. Meanwhile, Clause 30 introduces a new Section 117A detailing additional individuals who may be governed by military law. This section specifies persons not part of the defense forces that may be subject to military law under exceptional circumstances. From the above, the provisions indicate two categories of individuals under military law: a member of defense forces and a civilian involved in activities outlined in Section 117A. The committee notes that amendments in clauses 29 and 30 of the bill seek to bring the Principal Act into accordance with court's ruling in the Constitutional Appeal number 2 of 2021. This, Attorney General versus Michael Kabaziguruka, which included several observations, recommendations, and other regarding individuals governed by military law. Following consultations with various stakeholders on the bill, the committee encountered diverse opinions on the Supreme Court's orders, effects, and recommendations regarding civilians under military law. Some witnesses objected to trying civilians in military courts, arguing that Supreme Court's interpretation prohibits such actions. In contrast, other committee members and stakeholders, including the learned Attorney General and the Minister of Defense, contend that the Supreme Court did not fully ban civilian trials in military courts, suggesting instead that such trials could occur under exceptional circumstances. The committee has examined this matter and concludes that the trial of civilians by military courts should occur only in exceptional circumstances, ensuring that a fair trial is guaranteed. The committee acknowledges that military laws apply to officers and personnel within the defense forces, but they also address elements of national security. As a result, civilians can engage in actions that usually impact national security, which are typically reserved for those under military law. The reasoning for establishing offenses in the UPDF Act that hold civilian criminally liable is to safeguard national security. The committee reviewed the exceptional circumstances outlined in the bill and determined that certain aspects require revision to align with the legality principle. Specifically, the committee identifies that paragraph D, which allows the trial of civilians in military courts for aiding and abetting individuals subject to military law in committing serious crimes such as murder, aggravated robbery, intent to murder, kidnapping, treason, misprision of treason, or cattle rustling need adjustment since it fails to specify the elements of these offenses. This omission compromises the legality principle defined in Article 28(12) of the Constitution. Furthermore, the committee observes that while civilians are penalized for aiding and abetting these crimes, primary offenders face no penalties. The committee supports the proposal for trying civilians in exceptional circumstances, provided that amendments to the UPDF Act ensure a fair trial. This requires changes to the military court structure, to ensure that those presiding over these trials have legal training and appointed through a transparent process, a function independently of their superiors' influence. The committee, therefore, recommends that clauses 29 and 30 form part of the bill, albeit with amendments as proposed. 6.12, restructuring of courts martial in alignment with the Constitution, particularly Article 129(1)(d). Right Honourable Speaker and Honourable colleagues, the proposed restructuring of the military courts as outlined in the bill aims to align the unit court-martial, division court-martial, and the general court-martial with the Constitution under Article 129(1)(d) of the Constitution. It introduces provisions on the qualifications, appointments, tenure, and jurisdiction for the service offences. Additionally, the bill establishes military courts department to oversee justice administration within the defense forces. However, the committee noted that the roles and functions of the military courts department are vague, leaving gaps in oversight and accountability intended to oversee military courts. The structure risks undermining judicial independence. The military courts department includes the head general court martial as chair, along with military prosecutors, defense counsel, and chairpersons of the military courts. This overlap of judicial and prosecutorial roles is seen as a violation of natural justice principles. It threatens the right to a fair hearing by compromising impartiality of the court. Additionally, a key concern arises from the provision allowing the Chief of Defense Forces, in consultation with the High Command, to assign an acting rank to the head of the General Court Martial when the accused has a higher rank. While intended to maintain order, this mechanism may introduce bureaucratic delays and allow manipulation of the justice process. For instance, the Chief of Defense Forces could delay rank assignment impeding the prosecution of senior officers. The temporary rank, with its associated privileges, may also incentivize judicial officers to prolong proceedings to retain benefits, hence compromising timely and impartial justice. The committee therefore recommends that the proposals contained in the bill regarding composition and structure of the military courts should be supported, albeit with amendment to engender fair trial provisions as proposed in the committee's amendments. Appointment of the presiding officers and members of the courts martial. Right Honourable Speaker, the committee notes that Supreme Court emphasized that military courts, despite being specialized, exercise judicial power and must therefore uphold the same safeguards of independence and impartiality guaranteed under Article 129 of the Constitution. While the bill...
129 or 128?
120, I beg your pardon. Guaranteed under Article 128 of the Constitution. While the bill amends qualifications by requiring legal training for the presiding officers, committee expressed significant concern over the appointment process. Currently, all members are appointed by the High Command from a list it generates in consultation with Judicial Service Commission. This system grants the High Command broad powers to appoint members for specific trials, raising serious doubts about the members' independence and vulnerability to external influence. The idea of consulting Judicial Service Commission does not explicitly define the role of Judicial Service Commission in the process of appointment. The committee argues that the Judicial Service Commission should be given a stronger role to vet presiding officers who wield judicial power. The committee contends that military courts must be governed by judicial oath and legal principles. We therefore recommend that persons presiding over military courts should be appointed by the Commander-in-Chief on the recommendations of Judicial Service Commission from the list generated by the High Command. Tenure of service. The bill allows a 3-year renewable tenure for chairpersons of court-martial, but is silent on the terms of other members. The committee noted that secure tenure is vital for judicial independence, safeguarding judicial officers from arbitrary removal or political pressure. A 3-year term is inadequate, and unclear removal grounds for members create insecurity, risking impartiality. Citing Justice Asaph Ruhinda-Ntenje and another versus Attorney General, Constitutional Petition number 33 of 2016, which declared fixed term contracts for 5 years for all members and the defining grounds for removal to protect judicial independence. The committee recommends that a term of all members be increased from 3 years to 5 years and is eligible for reappointment. 2, that the term should apply to all members of the courts martial and not limited to the chairperson as proposed in the bill. Appeals from decisions of courts martial. The bill permits unit court martial to the division courts martial to the general courts martial, and from the general court martial to the Court of Appeal, with the Supreme Court as the final appellate court. The Attorney General explained that since the High Court lacks appellate jurisdiction over capital offenses, appeals for such cases must lay directly to the Court of Appeal. The committee agreed with this reasoning, but raised concerns about the practicability of requiring officers and soldiers in remote areas to travel to Kampala for the General Court Martial appeals. This could be costly and could hinder access to justice. Additionally, the right to appeal where the aggrieved party is dissatisfied with the unit court-martial decision has only right to appeals, while a division court-martial decision can be appealed to the Supreme Court where viewed as unfair. The bill restricts appeals on legal matters, making decisions of the chairperson of the unit and the division court-martial final. The committee deems this untenable as it prevents parties from challenging potentially erroneous legal decisions, risking miscarriages of justice. The bill's clauses on the appeal and enforcement of sentences, particularly regarding the death penalty, were also problematic. The phrase of notice of intention to appeal differs from a formal notice of appeal, creating ambiguity and risk that death sentences could be executed before appeals are determined, violating Article 22(1) of the Constitution. This article guarantees that no person shall be deprived of life except after a fair trial and confirmation by the highest appellate court. We therefore recommend, Right Honorable Speaker and Honorable colleagues, we recommend the following. 1, that appeals from the unit court-martials should lay with the division court-martial. 2, the decisions of a unit or division court-martial on matters of law and facts should be open to challenge. That appeals from decisions of the General Court-Martial should lay with the Court of Appeal as proposed in the bill. 4, proposed Section 2272 should be deleted and Section 2273 be aligned with the provisions of Article 221 of the Constitution. Structural reorganization of defense forces. The committee acknowledges vital role of Uganda People's Defense Forces that has played in upholding national security and preserving and defending sovereignty and the territorial integrity of Uganda. In light of the evolving security threats and expanding military responsibilities, there is a critical need to realign the UPDF structure. Structural reform is based on Uganda's legal framework, specifically Article 2010 of the Constitution that empowers Parliament to make laws regulating Uganda People's Defense Forces, and in particular, provide for the organs and structures of UPDF. Section 2 of the UPDF Act, Cap 330, provide for the mandate of Parliament to make laws, prescribe any services beside the land and air forces. At present, these two branches are central to the military operations of the UPDF, which also receives assistance from the reserve force during emergencies. A significant advancement has been the emergence of Special Forces Command, a specialized allied unit tasked with carrying out specialized missions or operations at the moment notice, very important persons, protection, and reconnaissance. While it is not legally provided for as a distinct service, the SFC holds a crucial position in linking conventional and special operations, collaborating closely with both land forces and air forces. The committee notes that the bill restructures the UPDF by creating new services such as the SFC and the reserve force to improve operational capacity and responsiveness. New organs such as the Joint Military Command and Service Command and staff committees are being established to enhance coordination, policy formulation, and strategic oversight. This reorganization also includes renaming and redefining roles in the command structure for clarity, for efficiency, and alignment with the current security needs. The committee therefore recommends that the proposal to restructure the UPDF to formally integrate specialized units such as the SFC as a distinct service branch should be supported to institutionalize specialized capabilities, enhance service coordination, and ensure compliance with the legal and oversight requirements. On veterans affairs and pension reforms, the committee notes that the bill proposes transferring administrative and management of pension and gratuity from the Ministry of Public Service to the Ministry of Defense and Veterans Affairs, aiming to enhance service delivery and more effectively to meet the needs of the military personnel. A key aspect of this reform is the establishment of the Pensions Appeals Board to provide a formal mechanism for addressing grievances and disputes related to pension matters. Additionally, the repeal of the Uganda Veterans Assistance Board Act Cap 221 signifies a shift towards a more integrated and updated legal framework. These reforms also introduce comprehensive provisions for retirement benefits, gratuity, and pensions, including entitlements related to death in service and disability, ensuring improved welfare and dignity for the serving personnel and the veterans alike. The Kampala reduction in force UPDF veterans informed the committee that although they voluntarily enlisted in the National Resistance Army struggle, which ultimately resulted in a change of government, they continued to serve in the NRA UPDF until their discharge, which occurred without a proper and formal dismissal. The committee notes that the UPDF has transformed since the 1990s, following significant military downsizing after achieving stability post-internal conflict. This began demobilization efforts, and restructuring of the UPDF alongside pension reforms for veterans. The reduction in force affected thousands of personnel, especially older veterans, and non-combatants, aimed at enhancing security and lowering public spending. However, systemic issues in the pension system emerged as many veterans faced unclear entitlements, delays, and bureaucratic hurdles in obtaining their benefits. Scholars such as Obore in 2006 highlight that while legislation aimed to guarantee pension rights, many veterans remain unrecognized due to inadequate documentation or unclear classifications, e.g. informal service or voluntarism, not recognized as pensionable. Thus, the committee believes that while the bill will strengthen the pension and gratuity administration for the UPDF veterans, actual realization of the rights remains uneven for the demobilized veterans. Additionally, the bill currently excludes individuals or militants who retired before its enactment, which lacks a commencement date. Its provisions have no retrospective effect and do not address retired officers and militants. Right Honorable Speaker and Honorable colleagues, we therefore recommend, 1, that decentralization of the pension authority to the Ministry of Defense and Veteran Affairs as proposed in the bill should be adopted to enhance efficiency, transparency, and responsiveness in addressing pension-related issues for military personnel and veterans alike. Welfare and health services. The committee observes that the bill proposes establishing a health care service.
Madam Speaker, I'm rising on point of order. Earlier you had ruled that this front bench be reserved. As it is now, the several members appear to be part of my team, but when I invite them to support me, they shy away. Is it in order that they sit here is it in order for them to continue defying the ruling that you made, that this front city be reserved for the members? Is it in order?
Honorable Wilson, continue.
Thank you. Right Honorable Speaker, I am now addressing committee's concerns and observations on welfare and health services. The committee observes that the bill proposes establishing a health care service for the Defense Forces personnel, creating a dedicated health care service for the military personnel,
listen to the
introduces, Right Honorable Speaker, creating a dedicated health care service for the military personnel introduces extensive health care system, including routine medical care for the dependents of the officers and militants, rehabilitation services, and access to specialized treatments abroad when necessary. Additionally, a Defense Forces Medical Board has been established to manage medical evacuations, to manage medical evaluations, conduct disability assessments, and approve treatment for officers and militants. These reforms are designed to ensure that all military personnel receive timely, effective, and specialized health care during their service and after their service. The committee opines that a dedicated health care service for the defense personnel, separate from civilian, addresses a unique nature of military service requiring specialized, timely, and continuous medical support tailored to risks faced by the defense forces. Military personnel often need rapid access to trauma care, rehabilitation for service-related injuries, and treatment for psychological conditions from combat or deployment. The Defense Forces Medical Board will ensure medical evaluations, disability assessments, and treatment decisions aligned with the military standards and readiness, which civilians' health care may not adequately address. The committee The Joint Committee therefore recommends that 1. Establishment and operationalization of a dedicated healthcare service for the defense personnel, as opposed in the bill, be fully supported and adequately resourced to ensure the delivery of specialized, timely, mission-specific medical care, addressing the unique medical and psychological and rehabilitative needs of the military personnel. Monopoly and security classifications. The bill introduces measures to strengthen monopoly and security classification concerning crucial military assets of the UPDF. It specifically outlines which arms and ammunition are solely under the control of defense forces, guaranteeing that these materials remain inaccessible to unauthorized parties. Additionally, the identification and safeguarding of classified equipment and materials will now be regarded as sensitive to national security and will be strictly regulated according to military protocols. These reforms, Right Honorable Speaker and Honorable colleagues, aim to bolster national security, prevent unauthorized access, and uphold operational integrity by ensuring that only designated military officials oversee and protect these assets. However, the committee observes that the classification and categorization of materials under the exclusive control of the defense forces, particularly military uniforms, can have significant implications for civilian wear. When clothing that closely resembles military colors, patterns, or designs are classified as military property, civilians wearing similar attire or clothing may face restrictions or even legal consequences. This is specifically in context where the resemblance is coincidental or fashion-based rather than intended to personate military personnel. For instance, in the bill under Clause 82, Schedule 7B, several uniforms for ceremonial wear, including ordinary black shoes, kaunda suits in the coffee brown, blue, and khaki, have been categorized as exclusive wear for the defense forces. Yet, these are very colors of clothing and black shoes are seen as ordinary wear by the public. Be that as it may, the committee asserts that civilians wearing military-style attire and berets, even without official insignia, significantly risks military identity, public trust, and operational scrutiny. Such apparel can confuse the public, undermine military distinctiveness, and grant an earned authority to those not following military codes. In operational or emergency situations, the difficulty in distinguishing trained service members from similarly attired civilians may compromise coordination and increase risks, potentially damaging the armed forces' professional image. Recommendations. We therefore recommend that Schedule 7B should be amended to include a requirement for marking military stores with the logos and insignia of the UPDF, thereby distinguishing them from civilian items. 2, that a provision should be inserted to restrict the wearing of camouflage military-style uniforms and berets by individuals who are not part of the military. Conclusion, Right Honorable Speaker and honorable colleagues. We therefore recommend that the bill be considered for the second reading, subject to the proposed amendments attached hereto and any other modifications the House may propose and approve. Right Honorable Speaker and honorable colleagues, I beg to report.
Thank you. Thank you so much. Thank you. As you are informed that we have a minority report from Junior, Okot Moses Junior. Please present your report. Go to areas of dissent.
objection. I'm not speaking.
Abib, you extend, you're disturbing Junior.
The Right Honourable Speaker and members, I move to present the minority report. But prior to the presentation, I intend to make an opening statement. In arriving at this report, we, the members of the Joint Committees of Defense and Parliamentary Legal Affairs, did in a higgledy-piggledy manner haphazardly reached a position that would qualify the report that I am reading to be the majority report. And to justify the same, we had about 14 members signing this report out of the total number of members of these two committees.
How many members signed the majority report? Let's get a difference between majority and minority.
Right Honourable Speaker, the majority report has been signed by a total number of 26 members.
The joint, yes, then the joint 14 decide, okay.
While I finish making my submission prior to reading to this report, is that I want to urge the members that if reason, persuasion, logic, and science has never taken the day in this House, let it take today, because this is a very critical part of the bill that I decided out of the opposition to remain in this House so that I present logic, science, reason, and law to the House.
Just finish and wait.
There's an order.
Thank you very much, Right Honourable Speaker. I rise on a point of order. This House is constituted of distinguished ladies and gentlemen representing this country, and we've been handling business since the beginning of this term. Is it in order for my friend to say we are illogical, that we have never applied logic in this House, and it is only him who is illogical in this House? When we represent our different constituencies, is in order to demean and insult us as members of this House?
Thank you. The members of this House reason with the reason and with the logic. And these are honorable members of Parliament. So whenever there is a debate here, it is done with the logic and reason. So we cannot have a House belittled to that level. So Junior, withdraw your statement. Junior.
Rightfully so, Right Honourable Speaker, I withdraw.
Honourable members, allow me to chair the House. Junior has withdrawn the statement and will be expunged from the Hansard. Because the members that we have here are members of logic and reason, and they are honourable members of Parliament. Yes, Junior?
Right,
you go and look for them.
Right Honourable Speaker.
Junior, continue.
Right Honourable Speaker, if the House may please, I will read
your report.
Right Honourable Speaker and colleagues, this is the statement of the minority members of the Joint Committee of Legal and Parliamentary Affairs, Committee of Defence and Internal Affairs on the decision of the majority in respect of Uganda People's Defence Force Amendment Bill 2025, herein referred as the UPDF Amendment Bill. This statement is made pursuant to Rules 214 and 215 of the Rules of Procedure of Parliament of Uganda. The UPDF Amendment Bill 2025 was read for the first time on Tuesday, 13th of May 2025, and in accordance with the Rules 134 and 200, referred Joint Committee of Parliamentary Legal Affairs and that of Defense for scrutiny. The object of the bill is to amend the Uganda People's Defense Force Act, Cap 330, to majorly give effect to the decision of the Supreme Court in Constitutional Appeal number 2 of 2021, Attorney General versus Honorable Michael Kabazaruka, among others. Pardon, members, I am born, raised, nurtured of a Luo descent, and there are certain syntaxes that may not appear.
Go ahead, Honorable Kabazaruka.
The decision of the Supreme Court in the Constitutional Appeal number 2 of 2021, Attorney General versus Michael Kabazaruka, is well detailed and uploaded. I am going straight to read the point of dissent to allow members probably. Point of dissent is on 330. And this is the substance of our submission. Our dissent from the majority is guided by Article 9 by the 1995 Constitution of the Republic of Uganda and the Supreme Court judgment in Attorney General versus Michael Kabazaruka, Constitutional Appeal number 2 of 2021, arising from Constitutional Petition number 45 of 2016. As a locus classicus case, in addition to other authorities, the point of dissent are: 1, contravention of the Constitution; 2, illegality in military trial; 3, offending the doctrine of separation of power; 4, lack of public participation; 5, unconstitutional expansion of the military court's jurisdiction; 6, constitutional limitation on Parliament's power; 7, lack of independence and impartiality of the court-martial; 8, non-compliance with the judicial advisory order of the Supreme Court ruling. Members and Right Honourable Speaker, on issues of contravention of the Constitution, Article 92 of the Constitution provides a restriction on retrospective legislation. Parliament shall not, if I may, Parliament shall not pass any law to alter the decision or judgment of any court between parties to a decision or judgment. The above provides a bar on legislative powers of Parliament in enacting any law that has effect of overturning or altering the decision or the judgment of court. Clause 30 of the bill proposes to introduce a new section, that is section 117A in the UPDF Act, to provide for other persons who are subject to military law. The provision requires that a person other than a member of the Defense Force shall be subject to military law under the following exceptional circumstances: where a person voluntarily accompanies any unit or element of the UPDF of the Defense Force which is in active service in any place; B, where while serving in Defense Force under the engagement by which he or she has agreed to be subject to military law; C, where the person is in unlawful possession of arms, ammunition, equipment, ordinarily being a monopoly of the Defense Force, prescribed in Schedule 7A of this Act, or classified as stores prescribed in Schedule 7B to this Act, commits an offense under any written law; D, where the person aids or abets a person subject to military law in the commission or conspires with a person subject to military law to commit the offenses. The offenses below: 1, murder; 2, aggravated robbery; 3, kidnap with intent to murder; treason, prison of treason, or cattle rustling. E, where the person without authority is found in possession of or sells or wears a uniform of the defense forces, or where the person is found in unlawful possession of arms, ammunition, or equipment ordinarily belonging to the monopoly of the defense force prescribed in Schedule B of this Act. G, where a person is serving in position of an officer or a militant of any force raised and maintained outside Uganda and accompanied by the officer of the defense force. The above clause is an attempt to reenact Section 117 of the UPDF Act, which was struck down by the Supreme Court for offending Article 28(1), 44C, 128(1) of the Constitution. Such is inimical to the rule of law, good governance, which is a cornerstone of democratic dispersion, and that of other civilized nations and communities across the globe. It also constitutes an egregious attack on judicial independence, thereby contradicting Article 28(2) and 3 of the Constitution, which provides that no person or authority shall interfere with the courts or judicial officers in the exercise of judicial functions, and that all organs and agencies of the state shall accord to the courts such assistance as may be required to ensure effectiveness of the court. See Article 20 and 3. This action amounts of the Supreme Court is criminal, a path that must be leaded by Parliament. Honorable Speaker, Lucas Classicus case.
Do you have to add a dissent, Parliament? Must you add dissent? Nobody doubts that we are dissent.
Avoided by our Parliament. Mr. Blanche.
Expand the word dissent.
In the Locus Classicus case of ly'amagye in 1967, there is Parliament a retrospective law affecting the trial of individual accused of attempted coup. Council struck down the law on account that it sought to alter the course of a particular decision and effectively overturn the jurisdiction. The Indian Supreme Court in Indira Nehru Gandhi versus Raja Nara in 1975 SC 2299, after election was invalidated by the High Court constitutional amendment that was passed to validate the election. The Supreme Court struck the amendment, holding that the Parliament cannot enact legislation that overturns specific judicial decisions. Any legislation passed with the object of annulling the effect of a judicial decision has been held to be an encroachment on the judicial powers, and it is unconstitutional. Your Honor, coming down, there were other authorities that, Right Honorable Speaker, and colleagues, there were other authorities that were cited year after to persuade the House. I urge members to peruse while I go to deal with the dissent. The second area of dissent is illegality in military trials. Your Honor, Speaker, the question of a in military trial is ably canvassed by the Supreme Court in the case of Mike Kabaziruka in the above case. Owindolo CJ, in his lead judgment at 180 and to 180, this to Right Honourable Speaker. There are also other vital reasons militating against trials of persons to military law for all offences. These courts has previously held that there are certain offences that are not triable by the court-martial. This is so where a particular act grants jurisdiction under it only to the specific court. It would therefore be wrong for Parliament to cause a conflict by conferring on court-martial jurisdiction to try such offences. For instance, since terrorism can only be tried by the High Court, which is an ordinarily civil court.
Honourable Court Junior.
Yes, Your Honor.
Honourable Justice, Chief Justice Owindolo had this to say: open court, and then you close the court. Somebody will imagine
most obliged
that it continues up to the end.
Most obliged.
Close the court first.
Speaker. And if I may proceed from where I'd stopped, Right Honourable Speaker.
For clarity, say what Chief Justice said, open court, close it, then you bring your statement.
Right Honourable Speaker, the CJ, Justice Owindolo, in his lead judgment at page 180 to 185, had this to say. Open court. There are also other vital reasons militating against persons subject to military law for all offences. This court has previously held that there are certain offences that are not tried by the court-martial. This is so where a particular act grants jurisdiction under it only to a specific court. It would therefore be wrong for cause by conferring court-martial jurisdiction to an offence. For instance, since it can only be by High Court, an ordinary or civil, it would be contradictory to try it military court as well. And also it would be self-defeating for an offense similar to terrorism to be created under the UPDF Act, and then the persons are tried under it, close quote. I find this holding by Mulenga by Justice of the Supreme Court, Justice Mulenga, still position of the law, and where jurisdiction is expressly excluded, or where the DPP's consent is a prerequisite, the court-martial are not competent to handle that matter, so excluded irrespective of the provision to the contrary. Under the impugned section 117 and 117I, G and H of the UPDF Act, it amounts to duplication to grant jurisdiction to the court-martial over it when, owing to the gravity of these offences, Parliament conferred jurisdiction over them to ordinary courts. The other issue for consideration is the danger possessed by concurrent jurisdiction, where the military courts could try a case that is also before an ordinary court. This would necessitate the establishment of a mechanism between the court-martial and the DPP to manage the cases, beyond mere provisions in the UPDF Act, and the jurisdiction of the court-martial does not take away that of the civil courts. Concurrent trials in both military and ordinary courts for civil offenses would also be prejudicial to an accused, for a simple reason that it could lead to double jeopardy, as each court could potentially come up with a guilty verdict. Additionally, as already noted, the General Court Martial and other military courts are subordinate courts. See, in the case of Attorney General versus Uganda Law Society, Constitutional Appeal number 1 of 2006. However, I do not agree with Justice Mulenga's finding, where I held that the General Court Martial is subordinate but not lower than the Court Martial. According to the Black Laws Dictionary, Brian A. Garner, 8th edition, subordinate means placed in or belonging to a lower rank or class or position, or subject to another authority or control. Assigning an ordinary meaning to the word subordinate, all court martials as subordinate courts created under Article 129(1)(d) can only have jurisdiction that is lower than the High Court. Saying that it is subordinate but not lower than that of the High Court is contradictory and has the potential to create an absurdity when it comes to hearing of capital offenses. If Parliament desires to grant them the jurisdiction to handle capital cases, then it would need to do so in line with the Constitution. I will return to this later in advisory opinion to explore the options that could be undertaken by Parliament to achieve this effect constitutionally. With this finding, the hearing by all court martials of offenses within the jurisdiction of the court martial is under 128(1)(29)(d). Close quote. The general rule alone have jurisdiction civilians. The able any rational justification justify between the maintain this or maintain borders and civilians court generally. However, having held as above, the Chief Justice made the following orders. A. The provisions of 179(2) and now 171 and 2 of the UPDF Act.
171 or 177, 1 and 2.
179, 1, and then 1 and 2, and then 177, 1 and 2 of the UPDF Act. Read together with 197.2 and now 197.2, which grants subordinate military courts jurisdiction over capital offenses, contravenes Article 121(d) and 126 of the Constitution. They are unconstitutional. Provisions of Section 1 and G, now 1 and G is unconstitutional to the extent that it permits trial court martials of civilians who allegedly debated of or criminal offense in which a person subject to military law is a principal. Right Honorable Speaker, the minority observes, I'll jump D, the minority observes that the Supreme Court's decision had the following effects. The trial of civilians by court is only permissible in exceptional circumstances and only after state has concretely demonstrated to court by verifiable facts and by objective and serious reasons, need and justification for a recourse to a military court. 2, the minority observed that military courts can only have jurisdiction in relation to specific class, category of specific offense. For specialized courts such as Anti-Corruption Court under the Anti-Corruption Act, International Crimes Division under the Anti-Terrorism Act. 4, military courts cannot have jurisdiction of offenses which require the consent of the DPP. The consent of the DPP. 5, cannot commit or be tried for service offenses, even when abet or aid the commission of offenses. 6, when and military personnel are committed a crime, service offense, be tried in 7, government cannot duplicate offenses prescribed by acts of introduced in the UPDF. Colleagues, members of parliament, the appreciate the provisions of Article 28 to inevitable and incontrovertible conclusion that all persons, militant or otherwise facing criminal trials, to appear competent, independent, fair, impartial, or a tribunal. The decision of the Supreme Court, trial of persons with offenses
Man, valet took forever.
There's no valet here.
Who took my car?
That could have been bad.
Mountain Dew. Do the Dew. Togikwata nnyo buleki.
Disciplinary matters. That of this
Go to the third.
Honor, Speaker, offending of powers. Modern democratic organized three boundaries of government, being a crucial in particular preserve of government. Supreme Court covered may that are consistent with justice. The administration of justice of the right to provide ensure fair instruments The bill removes the following courts and trial processes. A, the commanding officer or officer commanding. 2B, trial by superior authority. C, court-martial, court of appeal. D, field court-martial. E, summary trial. Despite the aforementioned, the bill did not respond to the orders and recommendations of the Constitutional Appeal number 2 of 2021 Attorney General versus Michael Kawasaki is concerned. Colleagues, I am persuaded to take you further to our next point of dissent, appreciating that you have read what we are talking about. Colleagues, I have seen the labor you've had to listen to these submissions because it is aided by legal gymnastics and quoting of cases. But please listen. Let me go to recommendations. Recommendations. The minority finds that the provisions of clauses 30 specifically proposes Section 117A, proposed Section 117A is unconstitutional, irregular, and illegal as far as it allows the trial of civilians by military courts in the circumstances that are not exceptional. B, it extends to the jurisdiction of military courts. It extends the jurisdiction of military courts to the entire civilian population and to all offenses which ordinary courts are in position to try. C, the bill also extends military courts to cases reserved for specialized courts such as the High Court. The bill extends service offenses to civilians. Minority cautions Parliament to introduce them to the UPDF, where therefore recommend that the same be rejected. 4.0, lack of public participation. The Constitution in Article 38, 1 and 2 thereof reaffirms the right of everyone to participate in a fair in the plenary, which started at 2 p.m. The requirement of public participation is rooted and entrenched in our constitutional framework and must not be cosmetic reasons. Colleagues, various stakeholders were therefore locked out of the process due to this clearly cosmetic semblance. In the view of the minority, this did not meet the required standard of public participation. Indeed, apart from the Attorney General and the sponsoring minister, the committee interacted with only two other stakeholders. That is the DPP and Council Jude Biamukama. One would wonder why a matter of great national importance of this magnitude would only attract two external stakeholders. This is unprecedented in matters of this nature. On this account, in addition to other reasons given, the minority invites Parliament to reject the bill to the extent proposed herein. This was the conclusion of the minority. Right Honourable Speaker, whereas reforms within the UPDF Act are necessary to address contemporary security challenges, such reforms must not compromise constitutional rights. Judicial independence or civilian oversight. We, the minority, persuade this Parliament to reconsider the provisions of the UPDF Amendment Bill 2025 to ensure they align to the principles of democracy, rule of law, and respect respect of human rights. Therefore, the minority unanimously are of the opinion that the General Court Martial and other courts do not have constitutional jurisdiction to try civilians or adjudicate non-disciplinary criminal offenses, even if committed by members of the Uganda People's Defense Force under Article 210 of the 1995 Constitution. Parliament's power to legislate for military courts is strictly confined to matters of discipline and removal of the UPDF. Members, military courts are therefore internal discipline bodies, not general criminal courts, and cannot override the constitutional mandate that all criminal justice, including a fair trial right under Article 28 and 44, lies with the courts of judicature.
Thank you.
Members, this was jointly and severally the report by the minority. Back to submit.
Thank you. Thank you so much. Honourable members, there are two minority reports. Not so, Chair. There are two minority reports.
Right, Honourable Chair, as is our procedure, I am only aware of one minority report whose copy I ably tabled laid on the table. The second one, I am not aware, and it offends the rules of procedure, Right Honourable Speaker.
Yes.
The Right Honourable Speaker, according to the official information we have is that the opposition are officially boycotting this. I would wonder how my colleagues are masquerading here.
Honourable. Honourable members, opposition is in the house. Opposition is in the house. I see Honourable Kelo, Honourable Court, Honourable Olanya, Honourable Santa, Honourable Duru, who has ably presented a report, Honourable Namanya. Honourable members, Legal, did you get a report from?
I've just received a document. Someone came and dumped a document here. But I've just read, it is a minority report of the Honorable Jonathan Odur. I was not informed what it was, but I've just read and realized it is a...
The man did not attend.
After all, it's a minority. It's a minority.
Yes, Fox.
Thank you, Right Honourable Speaker. Right Honourable Speaker, I rise to move a motion.
No, there is still an issue of the minority of Honourable Dor, which the chair said was not given to him.
But, Right Honourable Speaker.
Honourable, yes, yes, Honourable Minister.
Right Honourable Speaker, since NRM believes in democracy, we should allow Honourable Dole present to the House.
Honourable Chris.
Thank you very much, Right Honourable Speaker. We make the rules ourselves as a parliament. and we must respect our own rules. Anybody to abuse provisions of our rules. If the rules require that a member dissenting must formally process his report, give it a chair, let it be. Let's not allow abuse of our rules. And therefore, if he has not followed what the rules provide for, we should not listen to that report.
Honorable members, let's not be suffocating in a member. Let's honor him up with this report and give us a summary of his report, his areas of dissent. Let him do it.
Thank you. Thank you very much, Right Honorable Speaker. Madam Speaker, for the record, this morning, I made a phone call to the chairman of Legal and Parliamentary Affairs Committee, and I told him on the phone that I have a minority and the chair is here. Secondly, when I reached Parliament, I again notified him on our platform, and then I filed this report with the clerk of our committee, who duly submitted to the clerk to Parliament. It has been duly stamped as received. So the record should show that I am not smuggling, I'm just complying with the rules. Madam Speaker, before I read, I beg these two situations for members to bear with me. First of all, as Honorable Ochero rightly observed, the opposition, my boss, has led a walkout as Shadow Minister for Justice and Constitutional Affairs. You can imagine the situation. They finish and I get fired. So allow me to present this report here. Secondly, in times like this, you would beg that me during the ruling court at myself and many others against the Attorney General, when their lordships had judged 3 against 3, the last judgment was by the Chief Justice Bart Katurebe, and when he had begun to read, he informed us that his glasses and the eyes had a problem and he needed to be rushed to South Africa immediately. I pray when I'm reading this report, my glasses don't fail me. Having said that, Madam Speaker, introduction. This is a minority report in dissent of the majority report of the Joint Committee of Legal and Parliamentary Affairs and the Committee of Defense and Internal Affairs on the Uganda People's Defense Force Amendment Bill 2025. This minority report is brought under Rule 215 of the Rules of Procedure of Parliament, areas of dissent and statement of reasons for dissent. The minority restricts the areas of dissent majorly on the policy and principles, defects in the existing law, remedies proposed in the bill, and specific provisions of the Uganda People's Defense Forces Amendment Bill 2025, touching the courts martial and related matters, including the schedules approach. In this minority report, it presents specific thematic areas of dissent, the reasons for the dissent, and explanatory statements for the reasons of dissent, and this minority report is guided by the provisions of the 1995 Constitution of the Republic of Uganda, the applicable subsidiary legislations, and the lead judgment in the Supreme Case, Attorney General versus Michael A. Kabaziguruka, Constitutional Appeal number 2 of 2021. Therefore, Right Honorable Speaker, each word, sentence, paragraph in this report has been carefully considered by the minority for justifying the dissent from the main report of the committee. The minority prays that time be allowed for this report to be presented to the House, both verbatim and seriatim. Thank you. Preliminary and substantive discussions on points of law. In this report, the minority raises several points of law in both preliminary and substantive forms. The minority submits that meaningful debates and decisions of Parliament can only take place after the presiding officer has disposed of, by way of a formal ruling with reasons all the points of law raised. The presiding officer should not be tempted to sweep under the carpet, fail or casually dismiss these important issues of points of law raised by the minority. In short, the minority invites the full attention of the presiding officer during the presentation of this report and prays for the rulings to be delivered on record in a timely manner before debate ensue. Breach of Rule 75 of the Rules of Procedure of Parliament on Sub Judice. During the consideration of the bill, the Uganda Law Society brought to the attention of the committee and Parliament an active court case in the East African Court of Justice, which court decisions are binding on Uganda as set out in the landmark precedent case of Among A. Anita versus Attorney General of Uganda and another, reference number 6 of 2012. I produced the letter dated 14th May 2025, and it is addressed to the clerk to Parliament and reads as follows. Reference, the Uganda People's Defense Amendment Bill 2025. Greetings from the Council, Management and staff of Uganda Law Society. In response to your invitation to meet the Joint Committee on Defense and Internal Affairs and Legal and Parliamentary Affairs for consideration of the above captioned bill, for which we are grateful, this is to inform the Joint Committee as follows. 1. The Uganda Law Society received your invitation letter today at 11:50 a.m., scheduling a meeting for 12 p.m. on the same day. With the greatest respect, the time frame is manifestly inadequate for a thorough consideration of the 150-page bill and is incompatible with democratic accountability. 2. Be that as it may, the Uganda Law Society hereby brings to your attention reference number 14 of 2025, Uganda Law Society versus the Attorney General of the Republic of Uganda, pending before the East African Court of Justice. Discussing the bill's provision on military courts would inevitably breach the sub judice rule, contrary to Rule 75 of the Rules of Procedure of Parliament of Uganda, Statutory Instrument number 43 of 2025, and Article 38, Sub-Article 2 of the Treaty for Establishment of the East African Community, and potentially contravenes Articles 2, 20, 79, 3, 92, 126, 1, 128, 3, and 287 of the Constitution of the Republic of Uganda. 3. Given the pending litigation, we respectfully request the Joint Committee to urge government to pursue amicable resolution of the dispute before engaging Parliament and on the contested matters. The Uganda Law Society welcomes the opportunity of another invitation to discuss the rest of the bill. Yours, it is signed by Ewan Asimwe, who is the Vice President of Uganda Law Society. I don't know for what reason why the President is able to sign. I now beg to lay on table the copy of duly received by the Office of the Clerk, as well as a copy of the reference number 14 of 2025 Uganda of Uganda Law Society versus the Attorney General of the Republic of Uganda. Madam Speaker, this document is already part of the minutes laid by the committee. If it is not there, I have a copy that I can lay. In the same vein, the minority also draws to the attention of the Right Honourable Speaker of Parliament and Parliament the constitutional application number 01 of 2025, Male Mabirizi K. Kiwanoka versus the Attorney General, filed in the Supreme Court of Uganda on 14 April 2025. And the same has been duly served upon the respondent who is present in this sitting. The gist of that application is that the Supreme Court should determine whether the action of the respondent, General and Government and Parliament, of proposing and consideration of the Uganda Defence Forces 2025, providing for trials of civilians in the courts martial, is contemptuous judgment of the Supreme Court in Uganda, in Supreme Court of Uganda, in Attorney General versus Michael, which I have already. The constitutional application number 01 of 2025, as referred, filed in the Supreme Court, has already been duly served. The respondent, the Attorney General, is present in this House and can confirm or deny the existence of this live case. All that the minority is belaboring by this submission is to demonstrate by all standards that there is a live and active dispute, not only before the East African Court of Justice, but also Uganda's highest court, the Supreme Court. It will be quite embarrassing for Parliament, an institution central to democracy and the rule of law, to carry on with the consideration of the Uganda People's Defence Forces Amendment Bill 2025, well aware of the court cases that touch on the subject matter of in the bill. The finding of the minority. The minority finds that Parliament proceeding to consider the clauses of the UPDF Amendment Bill 2025 touching the subject matter of trial of civilians in the undermines the core tenets of the rule of law, the doctrine of mutual respect for separation of powers between the executive, legislature, and judiciary. The next is on retrospectivity of legislation, contrary to Article 92 of the Constitution of Uganda. Article 92 of the Constitution of the Republic of Uganda on retrospective legislation states as follows: Parliament shall not pass any law to alter the decisions or judgments of any court as between the parties to the decision or judgment. Decisions or judgments of courts are categorized into two: one in personam and two in rem, to mean against a person and the world at large. The considered opinion of the minority, that judgment in Constitutional Appeal number 2 of 2021, Attorney General versus Michael K. is firmly binding on the movers of the bill as well as this Parliament. In short, unless Parliament is deliberately and with utmost impunity dismissive of the judgment of the Supreme Court of Uganda, which judgment was led by none other than Honorable the Chief Justice of Uganda, Alphonse C. Owindolo, together with his brother and sister lordships court, the Honorable Lady Justice Catherine Merere, the Honorable Lady Justice Monica Kalejera Mugenyi, the Honorable Lady Justice Faith Mwanda, the Honorable Lady Justice Elizabeth Musoke, the Honorable Lady Justice Percy Knight Tuhaise, and the Honorable Justice Mike J. Chibita, who did an splendid job. And I who are still that when you get children, you can
leadership in Uganda. We surely don't wish to be the midwives to deliver this baby at all. Madam Speaker, let it also sink in our minds that at any one point soon in our lifetime, Uganda will have another president other than H.E. Museveni. The next president, as per the law, shall be the chief boss of the court-martial. This House may have already noticed the following names in no particular order of chances of being the president being discussed in the main as potential future presidents starting in 2026 and beyond. The Honorable Akena Jimmy James Michael Obote, the Honorable Chagulanyi Sentamu Robert, the Honorable Amuriat Patrick Oboy, General Kaino Rugaba Muhozi, General Mugisha Muntu, Honorable Norbert Mao, Right Honorable Aneta Mao, Colonel retired Dr. Kiza Warren Besige.
Honorable, I never wish to be a president. Remove my name from that list. I am satisfied with what I have, and I'm even getting out of politics. Don't put my name into this.
Madam Speaker,
no, my name is not for playing. My name is not for jokes.
Madam Speaker, allow since it's a one.
Please, my name is not for jokes. I never want. Honorable, it is my name.
Madam,
please remove it.
Yes, this is a one-member's report signed by me, and I can amend it. I want to withdraw. That's what the point I want.
Yeah,
to
withdraw. I'm not part of that.
That although I had said that the names were in the public domain,
public domain.
I beg to withdraw.
I have my own right.
I beg to withdraw and delete and amend this report by deleting the name Right Honorable Anita Among Annette from this report. And I accordingly withdraw and apologize to you, Madam Speaker. Please, the records are there. Please, I invite this House to carefully reflect on each one of them, their soberness, fidelity to the law, ideologies, actions, sentiments, service records, and imagine what each one of them is capable of using such provisions in the bill. The finding. The minority finds that legislating on clauses of the bill that touch on the decision of the Supreme Court, specifically enacting clauses to try civilians and soldiers who commit civilian crimes in the court-martial, contravenes article of the Constitution of the and amend this report by deleting the name Right Honorable Annette from this report. And I accordingly withdraw and Speaker. Please, I invite this House to carefully reflect on each one of them, their soberness, fidelity to the law, ideologies, actions, sentiments, service record. Imagine what each one of them is capable of using such provisions. The finding. The minority finds that legislating on clauses of the bill that touch on the decision of the Supreme Court, specifically enacting clauses to try civilians and soldiers who commit civilian crimes in the court-martial, contravenes Article 92 of the Constitution of the Republic of Uganda, in light of the case of the Attorney General versus Michael K.K., Constitutional Appeal number 2 of 2021. The next is dissent is understanding of the judgment of the Supreme Court in this case. Right Honorable Speaker, during the consideration of the bill in the committee, an issue arose as to whether there was a lead judgment to inform the consideration of the bill, or all judgments of the quorum mattered. The learned Attorney General informed the committee that the judgment of Honorable the Chief Justice, as is the lead judgment, whose final orders and recommendations guided the drafting of the bill. Whereas the minority considered the other judgments as equally important, in as far as several rulings therein, the minority, for purpose of harmony, agreed with the Attorney General to restrict discussions around the lead judgment of Honorable the Chief Justice, Alphonse C. Owindolo, who 6 specific issues that the Supreme Court was required to resolve, and the issues are as follows. The first was whether the court-martial are courts established under the Constitution or are mere tribunals. 2, whether the court-martial can be or are independent and impartial within the meaning of Article 28 of the Constitution. Whether civilians can legally be liable to face trial in the court-martial for disciplinary offences, herein called military, disciplinary or service offences, stipulated in Part 6 of the UPDF Act. 4, whether citizens can constitutionally or legally be tried in the court-martial for civil offences not comprised in Part 6 of the UPDF Act, but are instead provided for in other legislation. 5, whether it is constitutional for persons subject to military law to be tried in the court-martial for offences outside the UPDF, for civilians to be tried by the court-martial as principle for offences 119(1)(h) of the UPDF Act exists in the civilian. Each of the questions, as this will secondly and most importantly, now section of the UPDF Act, which establishes the general court-martial established under the law as a competent court, is constitutional. Our understanding of the above declaration is that it is duly established under the law and its existence with the Constitution. However, it must be clothed with the following: A, members of the General Court-Martial must be persons with legal qualifications. B, the members of the General be independent of the command and have tenure. C, there should be adequate time and facility in the preparation of defense by an accused person, as well as right of an accused person to due process and an appeal in capital offences. D, the convening.
Okay. That's worst day ever.
1191, now respectively 177, 10X, 117, and G of the UPDF Act are unconstitutional since the conviction on court-martials to try civilians. Our understanding, the understanding of the Attorney General of this declaration and 9 by the court is that civilians cannot be tried in military. Our understanding of this declaration 7, 8, and 9 by the court is that civilians cannot be tried by military courts. I quote from the Attorney General. The minority recognizes the mandate of the Office of the Attorney General under Act 9, 3 and 4 of the Constitution of the Republic of Uganda, to wit, shall be the principal legal advice of government, give legal advice and legal services to government on any subject. It may be recalled, Right Honorable Speaker, that in both regional constitutional petition number 45 of 2016, Honorable Michael A. Kabaziguruka versus the Attorney General in the Constitutional Court and in the Constitutional Appeal number 2, 2021, the Attorney General versus Honorable Michael K. The Attorney diligently and professionally offered legal services representation in court and lost all the arguments except the legality of existence and creation of the court-martial. However, how then does the executive and even parliament expect the same learned Attorney General to again go back to the court and Supreme Court to defend the same issues which he argued and lost. It must be very burdensome, tiresome, hopeless, and frustrating to be lawyer to the government in such scenarios. Sympathies to the learned Attorney General, Honorable Kriwa, and the team of learned friends in the chambers of the Attorney General who prosecuted the case. Can they face the same court again on the same issues already decided by court? They must. Reliably informed, asked to be excused from executing role of Attorney General. Then a Deputy Attorney General who was with us here, Honorable Mwesiga Rukutana, immediately he left this and he had the energy to marry even a young wife. So it is really burdensome, Attorney General.
Honorable Duru, you're going personal.
Please, I withdraw.
She has, I mean, what's wrong with marrying your wife?
Finding. Huh? I withdraw. Finding. The minority, therefore, finds that there is no basis to provide for trial of civilians in the military court as decided by the two highest courts of Uganda, Constitution and the Supreme Court. The minority further finds that there is no political, ideological, and security narration to justify to provide for trial of non-military offenses in the court-martial. Therefore, is shallow, unreasonable, and unconstitutional. Court-martials by the Supreme Court are established legally, hence there is no need to re-establish it. Court-martials as found by the Supreme Court, and this is what I have to pay attention to, are already established legally, hence there is no need to establish it. The question of restructuring of the court-martial is necessary, the later pointed out, not possible through provisions of the proposed bill. Subordination of the court-martial, that's the next of dissent. The Honorable Chief Justice, Alphonse Owendolo, in his judgment, found as quoted below. I open the quote. Additionally, as already noted, the General Marshal and other military courts are all subordinate courts. See the case of Attorney General versus Uganda Law Society, Constitutional Appeal, number 1006. However, I do not agree with the justice of the Supreme Court's finding, where he held that the General Court is subordinate, but not lower than the High Court. According to the Black Laws, Brian A. Ghana, 8th edition, subordinate means play it in or belonging to a lower rank, class or position, or to another's authority or control, assigning the ordinary English meaning to the potential to create an absurdity when it comes to hearing of capital offences. If Parliament desires to grant them jurisdiction to handle capital offences, then it would need to do so in line with the Constitution. The minority observes, Madam Speaker, that Article 129 of the Constitution of the Republic of Uganda provides for the courts of judicature as stated in the judgment. Article 129(1), the judicial power of Uganda shall be exercised by the courts of judicature, which shall consist of A, the Supreme Court of Uganda, B, the Court of Appeal of Uganda, C, the High Court of Uganda, and D, which is underlined, such subordinate courts as Parliament may by law establish, including the Cadi's Court for marriage, divorce, inheritance of property, guardianship, as may be prescribed by Parliament. Article 129 of the Constitution is on the jurisdiction of the High Court and states as follows, and we can read together. 1. The High Court shall, subject to the provisions of this Constitution, have unlimited original jurisdiction on all matters and such appellant and other jurisdictions as may be conferred on by this Constitution or other law. In light of the judgment of the Supreme Court, Madam Speaker, any court created by Parliament is inherently subordinate to the High Court. Any court created by this Parliament, whether we go ahead and create or not, is inherently by this provision of the Constitution, subordinate. We cannot create a court equal or higher. For any court to be created with either the same or higher jurisdiction to the High Court, it has to be directly created in the Constitution under Article 129, sub-Article 1, and listed either in, you can reflect, in Clause 1C with the High Court, meaning at the same level, or immediately before Clause 1D to exclude it from the subordination. The minority also observes further that conferring unlimited jurisdiction on courts created under Article 129, other courts other than the three courts of record. The minority also observes further that conferring unlimited jurisdiction on courts created under Article 129D, which we are about to do, of the Constitution is equivalent to amending Article 139, sub-Article 1 of the Constitution, to the extent of creating exceptions limiting the already unlimited original jurisdiction conferred by the Constitution of the High Court. I can repeat that. The minority observes further that conferring unlimited original jurisdiction on courts created under Article 129D, such as the court-martial of the Constitution, is equivalent to amending by infection Article 139(1) of the Constitution to the extent of creating exceptions limiting the already unlimited original jurisdiction conferred by the Constitution on the High Court. Is it therefore allowed to amend the Constitution through an amendment of an Act of Parliament? The obvious answer is no. The Constitution can only be amended in conformity to Chapter 18, Articles 259 to 263 of the Constitution of the Republic of Uganda. The minority submits that the UPDF Amendment Bill 2025 is not a bill for an act to amend the Constitution, and therefore cannot attempt by trickery or any other means, including fraud, purport to amend Article 139 of the Constitution of the Republic of Uganda. Right Honorable Speaker, the advisory order recommendations of the Supreme Court are stated in paragraph 10 on page 199, bullet E of the judgment of the Honorable, the Chief Justice Alphonse C. Owindol as follows. E, amend the Constitution, and pay attention, this is what the Chief Justice ordered or recommended. Amend the Constitution to establish superior courts within the military court system under Article 129, and clothe those courts created by amendment of the Constitution with the requisite jurisdiction and guarantee of independence and impartiality to try specific military offenses under existing laws committed by military personnel. F, the Chief Justice advised, provide in the UPDF Act for the High Court, which is already created and in existence, to sit as a court-martial with power to try all criminal capital offenses within the High Court's jurisdiction, and those unique to the military that attract maximum of life and death sentences. Grant the Chief Justice powers to assign judges to the military courts. A select number of military personnel can therefore act as assessors. Appeals to the court-martial appeals court would follow the same format, with Court of Appeal sitting as such. Magistrates' courts would assume the jurisdictions all over other offenses of a subordinate court. G, the Chief Justice says, make provisions in the UPDF Act for trials of civilians in the military courts to be only under limited circumstances, and only after the state concretely demonstrates to the court by verifiable facts and by objective and serious reasons the need and justifications for recourse to the military courts. This must only apply where, in relation to the specific class or category of persons, offenses in question, ordinary courts are not in position to undertake. This is the quote of the Chief Justice upon which this bill has been brought. The understanding of the minority on these advisory orders E to F and G above is that they are premised on the fact that all trials of both civilians and military personnel who commit non-service military offenses must be before civilian courts. In other words, the current civilian courts, Magistrates Court, High Court, Court of Appeal, and Supreme Court are all competent by all standards required under Article 28 and 44 of the Constitution of the Republic of Uganda to try any offense in the law books of Uganda. A question was put to the learned Attorney General on whether his trust, confidence, and belief, a question was put to the Attorney General on where his trust, confidence, and belief would lie in delivery of justice on the offenses proposed in the bill. Were those trials to take place premised on the same facts before either the civilian courts or the court-martial? So we have two sets of same offenses. Which of the two courts would the Attorney General trust? The learned Attorney General answered that both courts can and will deliver justice. The understanding of the minority on this answer is that the learned Attorney General confirmed that civilian courts in existence right now is capable of conducting any trial of criminal nature in Uganda without need to waste time and resources on the court-martial, which has unconstitutional structure. The structure, not the court-martial. The court-martial is constitutional, but its structure has unconstitutional structure, incapable of delivering a free, fair, and impartial justice to any accused person. Even, Madam Speaker, even if this answer is denied, the question to the government and the mover of the bill is the government of NRM in power for 39 years and who virtually recruited and appointed all the cadres, the investigators, the police, the prosecutors, office of the DPP, the arbitrators, the judicial officers? If we check on the record of the current structure of police, leaderships, and the rest, all of them have been recruited by this government. Are they therefore justified to complain on the incompetence, the weakness in the judicial system? The question is, the NRM government in power system. The question is, the NRM government in power for 39 who recruited and appointed all the cadres in the justice system, the police, prosecutors, and the arbitrators, the judicial officers, are they justified to complain competence, weakness in the civil courts to handle any case in Uganda? If minority was granted more time, Right Honorable Speaker, it would have produced on all cases of murder, aggravated robberies, terrorism proposed in the bill against person, including military personnel, which has been successfully prosecuted in civilian courts. By the time of writing this report, Madam Speaker, I had known that yesterday the High Court convicted a former soldier, a militant, of an offense. That demonstrates and strengthens my argument that actually the civilian courts right now can convict murder, aggravated robbery, etc. Minority invites the attention of members, especially those familiar with papers, to reflect on the proposal of the Chief Justice, which captured it of the advisory orders by the Chief Justice as follows. I'll put a heading there just to illustrate when we come to the amendment. All the headings of courts in Uganda would be written the Republic of Uganda. In the High Court of Uganda, it could be in Kamzampo, and in bracket, we put the provision for court-martial military division. That is what the learned Chief Justice had advised. The minority finds that the proposals in the Uganda People's Defense Forces Amendment Bill 2025, purporting to recreate the court with unlimited original jurisdiction is unconstitutional. It inadvertently amends Article 139 of the Constitution without following the procedure of amendment provided under Chapter 10 of the same Constitution. The minority further finds that administratively viable to provide for a specialized court within the courts for purpose of trial of criminal offences committed by the military person. The point of the dissent is on limited or exceptional circumstances. Madam Speaker, the minority recognizes the discussion, judgment on the limited circumstances of trials of civilian or military persons in the court-martial in Uganda. In the judgment, the minority stands that these circumstances appear to be strictly in reference where, and we can pay attention. One, the Constitution is not similar to the military rule during Idi Amin's regime. First condition for trial of civilians in the military court, there must not be constitutional. Two, courts of law have no capacity to try the offense. For example, there are shortages of competent judicial officers. Three, soldiers and civilians are duty or deployed in a foreign land where there is no possibility of return for trial in Uganda, and there is no other court in that country to try the accused. We all know where our army, the UPDF, are. So the court martials can try them there in case that country does all the situation of the war in that country. That is the understanding of the minority. Scenario of Karamoja, which was presented in the committee as a success story of the court martials, was unjustified. It was clear that judicial officers had feared to be deployed in Karamoja to years because of insecurity. These are the questions. Were other courts in the networks also unavailable to try those cases? Did the same government demonstrate to Uganda courts in Karamoja were fully functional when retired Dr. Kiza Besige was flown to Moroto and charged in the civilian courts? Who is mandated to ensure an order in Uganda? And why not deal with the root causes of it all, which is the security judicial officers, rather than recourse to the courts martial? Madam, were the trials free and fair in Karamoja? The presumption of innocence, the charges, were they read to them? Did they take proper plea? Did they give evidence as per the evidence? Was there a ruling on the prima facie case? Was there a defense? Were there actions? Did they allow them to plead to mitigate? And what was the sentencing guideline? In the opinion of the committee, it is foolish to legislate to provide for unconstitutional situations, leading for scenarios where the constitution laws are not enforced. All I am saying, I mean, cannot sit and legislate for a situation where the constitution is not. It would be foolish of us that. And as such, to make at least not very bullish. No, I just said it is. I didn't accuse anybody. Right on our to make all Ugandans liable for trial in the military system. First, all Ugandans. Madam Speaker, to make all Uganda able for trial in the military justice system. I can see.
From Miss Uganda is back on Star Times Makula Chika. All regions compete for one crown. Who will be the next true Ugandan beauty queen? Do you have the looks, the brains, the confidence? This is your chance. For registration, log on to www.missuganda.co.ug before 20th June. Miss Uganda 2025 premieres on 27th June at 8 p.m. on Makula Chika. Stay